It is interesting that, you know, the PDP primaries for Taraba were not the only ones conducted in Abuja, even though we don't know what the verdict would have been for the other primaries that were conducted in in Abuja as well. Some people say that there were also primaries for Taraba that were conducted in Taraba State at about that same time. Some people also ask, is it possible for a party, a political party, to go into an election without a candidate?
Is it possible for a party to go into an election without a candidate? Is it as a result of being shut out by the law, or they decided not to go to the election with a candidate? You recall the decision of Ararume in the past when Ararume emerged as the winner of the PDP, primaries, but because of political reasons, he was overlooked, and PDP did not field the candidate, or so to speak, or something like that. And then the Supreme Court looked at the matter and said, no, 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 no. This is not how election and electoral process should go. And then the Supreme Court did what was right in the circumstance. The Supreme Court actually looked at the overall interest of justice. In justice delivery, the overall interest of justice cannot be, put out of the equation when you're looking at that. So that's my view on it. That's my take on it. That even though there is a strict provision that you are to conduct the primaries within a certain period and you are to submit the list within a certain period, if you fail to do that, then what evidence have you led to justify the late submission? And if you have led an evidence, whether the court evaluated that evidence and believed in the credibility of that evidence or not, and whether the court believe or not, the court must rule on it. And then if the court rules on it, then the appellate court might be asked whether the ruling of that court in respect of that issue or matter was right, having regard to the issue of doctrine of necessity and the overall interest of justice.
Do you think that this case also tests, the classic case of Amici versus INEC, the Supreme Court ruling on that particular matter?
Right, but it can be distinguished, because in Amici and INEC, it was the case of someone who did not participate, and then and someone else was presented, and then the Supreme Court now corrected that situation. But don't forget that after Amici and INEC, there have been lots of related cases that have appeared before the Supreme Court, and the Supreme Court, clearly distinguished Amici and INEC. And as a matter of fact, after that, law was enacted to be able to correct that. That's Section 140 sub 2, to be fair and candid, was not introduced for fun.
Do you think that it has any inference? I mean, could it have any implications for this particular matter?
Obviously, my opinion is obviously.
But people will disagree, saying, look, there are two separate cases. This has got to do with whether or not the PDP participated in this election, but the Locus Classicus case of Amici 2008 talks about the rightful candidate to participate.
Yes, you're right. You're right. I said that they are not, these two cases are distinguishable. That's a fact. Okay. But what I'm saying is the case in point that we're talking about, there was primaries. It is just that INEC is saying the primaries was not conducted in line with the provisions of the Electoral Act.
All right.
The evidence was laid for and against. The court must have evaluated the evidence and arrived at the conclusion. So the issue when it goes on appeal is whether the evaluation of the court and the final ruling on the matter will be right in the light of the intervening, supervening situation.
Well, the tribunal went ahead and voided the votes of PDP and said it is a waste. Is the doctrine of wasted votes known to law?
I will say yes and no. I would say, if I say yes, then my argument will be that though the election and the votes that were cast in law can be considered as valid votes, but because the candidate for which the vote was cast, the court found that the candidate was not qualified in the first place, it is natural for you to reach that conclusion that the votes are wasted votes. But when I say no, I would say no because we have not had a decision of the final court on the matter. So, and it is interesting that this one is coming up because finally when it gets to the Supreme Court, we're going to get a ruling on that. But I do not think there's a problem with the pronouncement of a wasted vote because the issue here is not just limited to the vote cast, but the candidate who emerged as the winner, whether he was validly elected or not.
So in this one, would you say that the tribunal declared Al-Hassan in error?
my opinion is that the declaration was in error because the court ought to have considered Section 140 sub 2 in declaring the judgment. And if it did, then the court is not bound to give a different interpretation from the obvious provision that you shall not declare the person who scored the second highest vote as the winner, but you shall order a fresh election. And I think the sole issue, even when it gets to appeal, might be, assuming, might be the interpretation of Section 140 sub 2. I know that the tribunal may not have delved into the interpretation because it is not within its power to interpret the construction of a statute. But then, if it is presented to it, the tribunal must rule one way or the other on it. And on appeal, that provision of 1 Section 2, as against the decision of the Federal High Court, will now become the major issue before the court. Because if the Court of Appeal finds that the tribunal erred in law by not considering Section 140 sub 2, it will now definitely overrule the decision of the tribunal. And if the Court of Appeal decides that the tribunal was right to have considered 142 and went ahead to ignore that provision, then the Court of Appeal will give us the reasoning, which will probably open up a new law. And then it might go right up to Supreme Court, and then we get the final judgment on that. But don't forget that decision of the Federal High Court, even if it stands as a law, since it is not the final High Court, it is still challengeable, and the law has not rested. Definitely in Nigeria, with our electionary process, that must be tested finally, and we get the law on that.
All right, in the event that a rerun or fresh elections are conducted, will the 21-day notice still apply?
You see, when a judgment is delivered and you order a fresh election, the consequential order of the court is what will determine. Because at that stage, it is now the order of the court. In my opinion, it will no longer be considering what has been there in the Electoral Act before the dispute that arose, for which the Election Tribunal is now giving a fresh order. Because in Rivers, when it nullified the election, the court made a consequential order that there should be an election conducted within certain period. So my opinion is that it will be the sole discretion of the court at that stage.
Well, yes, institutions, individuals driving the entire scenario. How do you see this playing out? Are we likely to get, or what are the chances of us getting an EFCC that will not be beholden to the body language of their appointee, moving ahead and doing what they have to do?
Right, thank you. The sack of the chairman of EFCC, we saw it coming because during the past administration, as was canvassed by the learned Sikh earlier, the EFCC was not working, or if it was, Nigerians were not seeing it. And then when the president became elected, EFCC rose from her slumber. The question is, at the time of the past administration, there must have been petitions submitted to EFCC. What did the EFCC do? Now, the decision of the EFCC not to act around at that time, was it purely occasioned by the directives from the chairman or by the nature of the institution? Nigerians know that EFCC can be made to work if you have the right person there. But I don't even want to delve so much on the political issues surrounding EFCC, because I agree that if you bring a strong leader, you have a strong institution, because it is a strong leader. After all, it is a strong leader who has come on board that is making a lot of people to act even before they get instruction. Like we heard when the president they won the election, even before he was inaugurated, the various officers at our various airports were even refusing public officers, public officials, former public officials from traveling. So that also sort of disproved the contention that there is a presidential intervention on it. I know that by the very nature of EFCC and our arms of government, it is not possible for EFCC to operate without some sort of input from the presidency. My focus will be, actually, my concern will be whether or not EFCC will succeed in the campaign of anti-corruption war, because there are issues. The issue of investigation is there. So it doesn't matter who you bring on the helms of affairs. If EFCC does not change the character of investigation, look at the success rate of EFCC in the court. Very poor as far as high-profile cases are concerned. And the reason is simple, because EFCC has this character of not doing a proper and thorough investigation, and then they go to court. And if you have a defect on the face of a charge, or you haven't done your investigation properly, the chances for you to succeed will be minimal. Secondly, whether the federal government has enough money to even do the investigation, because we heard that it took £6 million for the British government to investigate James Ibori. We have canvassed at various quarters that if you want to successfully prosecute anti-corruption war, you must consider the concept of plea bargain. It is recognized by our law. And no country of the world desires to see people sent to jail like America. But America has the highest success rate of financial recoveries of looted funds simply because of the concept of plea bargain. So this is what I think that whoever emerges as the boss of PA, we read that someone was made a chairman yesterday, they will have to look at it if we have to succeed. Because why are we going for the anti-corruption war? Is it to recover the funds or to send them to prison? There's no doubt that sending people who are convicted to prison serves as a deterrent. But fundamentally, what we need is the monies that were stolen. And if you do not do a proper investigation, I'm afraid, we have seen it in court, cases of anti-corruption war, 7 years down the line, they haven't even gone on trial. So when are you going to have the money? After the person has spent all the money?
All right, then, that's where we'll have to anchor. Thank you very much indeed for your thoughts there. Daniel Bwala, legal practitioner and also an adjunct lecturer at Nigerian Law School, Abuja.